Hello, I am Ann Godlaski, President of the National Press Foundation, and I would like to thank everyone for joining me today for today's webinar, AI, Intellectual Property, and the Emerging Legal Landscape. This is a production of NPF's Evelyn Y. Davis Studios. Now, when it comes to AI and intellectual property, there are some fundamental legal issues at play, which we will see work themselves out in roughly 70 cases, the outcome of which could determine the flow of billions of dollars. So today we'll get a better understanding of the current legal landscape and what remains unresolved between AI companies and the creative economy in this exclusive online briefing sponsored by the Copyright Alliance and Next Solutions Group. As always, the National Press Foundation is solely responsible for the content that you hear today. We welcome journalists from across the country and around the world to submit questions using the chat or the Q&A feature. And to help answer those questions, we have a stellar panel of experts. Wayne Brow is an economist by training and currently a senior fellow at R Street Institute, researching antitrust and competition policy on its technology and innovation team. Terry Hart is general counsel for the Association of American Publishers and an adjunct professor at George Washington University Law School. He also previously served at the U.S. Copyright Office. Justin Hughes is a distinguished professor at Loyola Law School. That's Loyola Marymount, joining us from California. And he's a visiting professor at Oxford, as well as a former senior advisor to the U.S. Undersecretary for Commerce for Intellectual Property. And Deepa Seetharaman is a tech correspondent reporting on AI for Reuters. Thank you all for being here. So for our first round of questions, let's start with you, Professor Hughes, if you don't mind. Pretend we are a new class of law school students. If you could walk us through where things stand in terms of recently settled cases regarding AI and IP, particularly regarding fair use. I think that would be a great way to start.
Okay. Well, first of all, and thanks, Anne, for convening this fantastic group. And I just want to be clear that when we're talking in today's session about AI and IP, we're really focusing on copyright law because there are a whole set of patent issues. But on the copyright side of the equation of artificial intelligence and IP, the kind of two big issues that journalists should think of if you're trying to understand the terrain at the highest level is the training process for large language models and for other generative AI systems involves the copying of massive amounts of copyrighted materials. And there are different steps in that training process, and the steps in that training process, different points in the training process can have different ramifications based on the Copyright Act. So the question that has arisen in a vast majority of the cases is, what is the liability or potential liability of the AI companies for assembling these massive data sets and then training their systems on these data sets, which invariably involve massive amounts of reproduction of the copyrighted material. Then just to keep in mind, remember, there's a second big part of the lay of the land here in copyright and AI world, and that is the outputs. And are the outputs infringing? And in a number of cases, the plaintiffs have very clearly shown in the complaints that the AI systems are outputting clearly infringing works, that is, copies of the plaintiff's copyrighted song lyrics, copyrighted news articles, copyrighted novels. And so there's the output side. Now, one reason the two are related is that if you see that the system is outputting exact copies of the song lyrics or exact copies of the poems or exact copies of the novel or the news report, then it's reasonable to infer that it has been memorized into the AI system, meaning a copy is there. So you asked about the fair use point, and that is, of course, confronted with all these litigations where the copyright owners are saying, look, you have infringed massive amounts of copyright by reproducing without authorization and ingesting into your systems for these training sets, the AI companies have raised in the United States fair use. In other jurisdictions, there's been other litigation. In the European Union, there is a text and data mining exception, which has been litigated. Very interesting. There's 2 cases in Germany on that we could talk about, or I'd be happy to talk to anyone about later. But on the US side, we've had different decisions coming down different ways. And we've had at least a couple judges saying, well, the mere training itself may be fair use, but the retention of these large copy data sets and their replication and or you training from having taken pirated data sets, that's not fair use, because there are on the dark web these massive sets of data of copyrighted works. And instead of getting legitimate copies and training on that, which might have been fair use, you went out and got hundreds of thousands of copies of works that you knew were pirated from a pirated database, and that's not fair use. So that's what triggered the initial $1 billion settlement with Anthropic. And I think I've talked too long already, Anne, so I'll stop there. Did that okay to tee it up?
Thank you. Yes, that was helpful. So next I'd like to go to Terry, if you don't mind. So that's sort of a good lay of the land for everyone who's on, but what cases kind of in the year ahead particularly do you think journalists should be paying closest attention to?
Yeah, I'm happy to talk about that. And thank you, Anne. And it's a pleasure to be here. And just to start off, I want to give a standard disclaimer that any of the views I'm expressing are my own personal views and shouldn't be attributed to the Association of American Publishers or any of its members. Our members span the publishing world, from trade to education and textbook publishers to scientific and scholarly publishers. I mean, they're in the business of investing in authorship and investing in creativity and publishing. And the works they produce are really valuable to AI developers as training data, as we've seen, and particularly to large language models who use text and large amounts of text for training models. I think generally publishers are happy to work with AI developers in the marketplace to come up with mutually beneficial agreements. But as we've seen, there's been a lot of developers who have taken the kind of classic Silicon Valley approach of, ask forgiveness rather than permission. And so they have gone ahead and trained a lot of models using a lot of copyrighted works without authorization. And as you mentioned, there's over 70 lawsuits related to this issue in the US. We're tracking them pretty closely and count 75 at the moment. And that's just in the US. I think we're counting another 28 or so in jurisdictions outside the US. Justin mentioned a few in the EU and indeed around the world. But so it's hard to summarize them because at this point they involve not just text, but images, video, audio, and other types of works. I think by now most of the major AI and LLM developers have been sued at least once. And most of these lawsuits, at least the ones we're tracking, include a claim for copyright infringement arising out of the use of copyrighted works to train the model. That said, I'll mention a couple cases that I think at this point in time are worth keeping an eye on. But even 3 months, 6 months down the road, that may change because there's so many things, so many complicated factors involved that the landscape could quickly shift. I mean, I think this time last year, the Anthropic case that Professor Hughes mentioned, as well as a similar case against Meta brought by a group of authors, were not really on anyone's radar, but by the summer, both of those, the courts had reached decisions on fair use. And then subsequently, Anthropic reached a settlement that is now currently being underway in the court. So any one of these cases, could quickly move out front with things happening not just in the courtrooms but outside. As developers, maybe their calculus changes, maybe they're more interested in a settlement down the road because of things happening in the industry or broader. So that's a lot of throat clearing, but let me get to some of the cases at this point in time that are worth taking a closer look at. One is a consolidated class action that's been brought against Google. It's currently called In Re Google Generative AI litigation. This was originally 2 lawsuits, one brought by illustrators, one brought by writers that have been consolidated. And last October, the council moved to certify that as a class action. And so that's underway. And just a couple weeks ago, AAP, my organization, supported 2 publishers, Hachette Book Group and Cengage Group, one a major trade publisher and one a major education publisher, to intervene as class representatives for publishers there, and to support that class. They, in the motion to intervene, the publishers noted that they're united with the authors in that class. They believe that their participation will support and bolster the case against Google, and that they're also uniquely positioned to bring a lot of evidence and support to the legal and factual arguments that'll need to be made. So that is right now in the process of the court determining whether or not to grant class certification, in which case, if it does, then we're kind of where we were at with the Anthropic case, which was certified in July, and suddenly the doors are opened, and anyone whose works are implicated by Google's actions will be technically a member of the class. And so that's moving forward on that path, and we may see a lot of developments in the first part of this year there. The second one I'll mention, there's a massive multi-district litigation against OpenAI in the Southern District of New York. That's a combination of a lot of cases, but there's 2 groups of cases in particular worth noting. One is a group of direct actions brought by news and media publishers, including the New York Times, which had sued OpenAI. But then there's another group of class actions brought by authors, including one where the Authors Guild, the association that one of the largest author associations in the US, brought along with some fairly notable individual authors, such as John Grisham and Jodi Picoult. And so that case is currently in discovery. Plaintiffs have gotten some positive discovery outcomes there, in terms of requiring OpenAI to produce discovery related to some of the data sets that they downloaded from. And so that seems to be on a good track. And at least currently as scheduled, plaintiffs and OpenAI will be moving for the court to decide the issue of fair use beginning in the summer. And so they'll be briefing on the fair use issue on a fairly substantial record, and proceeding from there. So, we're keeping an eye on that one. For this audience, maybe also interested in watching another case brought by over a dozen mainstream news and magazine publishers against an AI company called Cohere, which is maybe not considered one of the front runners, but they're also, a fairly popular startup in the space. And I mentioned that one because that one was brought not just by this large group of news and magazine publishers that are kind of household names, but it's also been brought under the auspices of the News Media Alliance, which is the trade association for news and magazine publishers. And so that's got industry support behind it. They had an early win last November where Cohere tried to dismiss a couple claims, and the court rejected that and found that claims related to the infringing outputs that it's producing, which are particularly important, I think, for news publishers because if if large language models, if generative AI models are able to basically ingest news and provide something that's really substantially similar, I mean, that's directly impacting the ability of news publishers to get traffic to their own sites, which is critical to their ability to be able to recoup the investments that they make in journalism and reporting. So I think that one is one we're kind of keeping an eye on too. And finally, the what I'll end up with noting is, while we're looking at the text cases, the ones involving books and other textual works the closest, we also can't ignore the cases brought against image models, video models, and the like, because I think of, at least when it comes to fair use, it's sort of a Venn diagram where there are some distinctions between how the fair use issue will be analyzed, when you're talking about image or video on the one hand, text on the other hand, but there's also a big overlap there. And so what courts might say on fair use for an image model, a lot of that may be applicable in the text space. So we can't ignore those. I'll just mention a couple there. Getty Images, of course, a very large, both creator of original photos, photojournalism, but also licensing of stock photography and a lot of other photography, was one of the first companies to bring a lawsuit against Stability AI. That got a little bit bogged down when it was originally filed, and they recently transferred that case to California, restarted it up again. So we're keeping a close eye on that. It's moving ahead. And then finally, three of the big film studios have brought cases against Midjourney, and these are large companies. They've got a lot of legal muscle behind them. So I think those cases involving Disney and Universal in one case, and then Warner in a separate case, are worth paying attention to. But again, ask me the same question in 3 months, and the answer may be different. You can't really ignore any of these cases because of the level of uncertainty. But certainly, plenty to keep you interested in this issue.
Yeah, it's certainly fast evolving. Thank you, Terry. And I have received some questions in from attendees, which I will be getting to shortly. First, I just want to go to our other panelists quickly. And I know that some of the folks tuning in are tech journalists, but some are journalists covering policy more broadly, or societal issues more broadly. And so it occurs to me, Wayne, that perhaps we should actually go even more macro, and rather than talking about specific cases, I wonder if, given your background in economics and technology, if you could kind of share for us from your point of view, what's really at stake here, what's kind of at the forefront of your mind when you hear about these disputes, and do you think a balance can be struck?
Absolutely. Thank you, Anne, for pulling us all together to talk about this. For me, it's a very important issue, and it does go well beyond sort of the creative content aspect of our economy. In fact, the ultimate benefits of AI, the LLM models, and all the other formats that it's coming forth in is economic. Virtually every sector of the economy is touched by what can happen through AI. We can see tremendous gains in the healthcare, personalized healthcare, identifying new drug discoveries quicker. All of these things are possible because of the role that AI will play in our future economy. And you see it in the energy sector, better management of our energy networks, better solutions to climate change. A lot of total societal welfare is enhanced through the use of AI. But at the same time, AI is a very disruptive technology. We've seen disruptive technologies in the past, and as they come online, they do tend to upset apple carts and upset the way old ways of doing business. We've seen it when the printing press was introduced, when radio came along, and live performances were threatened. There's always been these tensions between various groups and they're important tensions because obviously they're business models that have been very profitable and productive and provided real consumer benefits. So as we change, we have to think about what benefits, what's the new world going to look like, and how do we incorporate these benefits into our economic thinking. And with respect to AI, I do think these models are very transformative. The judges in these cases say they're transformative. But the question is, how do we address how these models are trained? And I think Justin was right when we say we have to look at the inputs and outputs distinctly. And I think on the input side of things, it's important to remember that these models are not expressive forms of work. They're basically taking what they're inputting and turning them into very abstract models with weights and biases that make statistical predictions. And that's basically what these are. These things are predictive models that based on this huge amount of data that they've scraped, come up with ways to help users as they ask questions. So it is a big question in terms of where is this data coming from? And and we have to remember there's all different kinds of content that goes into this, and there's different interests in the content. There's from blogs or small websites to professional highly advanced publishing companies and newspapers that have a stake in this. And when you look at how you address some of the situations arising, you have to think how does all of this scale up to the level of data that is being used? I mean, there's billions and billions of tokens in these models, so they're not small models. And if we're thinking about solutions and thinking about where we're going in terms of trying to get a realistic policy for AI, we have to remember that not all data is created equal. And I think we're starting to see that in the marketplace. Obviously, high valued content is you're seeing a response from providers of that. And I think that's why we're starting to see some of these licensing models that are coming around, because there are benefits from bargaining between the two sides on those issues. And so I think we will see in the real world high valued content will probably work out licensing, and there's going to be that aspect of the market as we move forward. But at the same time, licensing is not a substitute for fair use. And if it is a fair use, licensing is a separate issue, and you should keep that aside. But given the amount of legal uncertainty and with 70 plus cases, this is not going to work itself out in the next couple of years. Technology moves at a very fast pace. The courts and government policy does not move at that pace. So I think what we'll see is these licensing agreements are a way to eliminate some of that uncertainty. And so I think there's going to be some willingness on both sides to say, okay, we're going into a new world. It's very disruptive. There's new business models at play. So let's come up with some new ideas and new ways to do business together. So I think that's what we're starting to see as these models play themselves out. And the one other thing I wanted to highlight, and then I'll stop because I'm probably talking too long, is there's a new theory of market dilution that's sort of being kicked around by the Copyright Office and some others, whereas by sort of quote flooding the market with new authors or new products, you're affecting the price of a specific book. But I think that whole theory of market dilution is from an economic perspective is very weak, because what you're talking about is basically a change in relative prices, and anything can change relative prices. And if you're not talking about one specific expressive work or one author's work, it's very difficult to say, well, because we're flooding the market and because that changes prices, we need to step in and say that's an economic harm. That's a market at work. If you look at where markets for content have gone over time, we've gone from, take just sort of an adjacent field in film. I mean, how much has short form reels and like TikTok and Instagram eaten into television, eaten into the cinema? So the market is very dynamic right now. It's changing a lot, and there's a lot to consider. And I think, moving forward, we'll see the courts. We'll see. The courts will make their decisions. We'll come to more finality on some of these questions of fair use and what markets will look like. But in the meantime, I think we should see how these licensing agreements and see how these players in the marketplace start to reshape how they do business with each other.
Thank you, Wayne. Yeah, there's so much there, and deep, AI is complicated on its own, and the law is complicated on its own. When you are covering sort of the collision of these two spheres, how do you kind of cut through the jargon and make sure that not only that you fully understand, but that your audience does?
With great difficulty. I think that there's a lot of it is challenging, right? I mean, just even explaining the technology and how it works. I think Terry or Wayne may have mentioned this, that these are statistical systems that predict what the next token is. You explain this to somebody like, I don't know, like my mom or my cousin who has not in tech, their eyes glaze over. They're not interested. It doesn't speak to anybody. Which is why I think you've seen a lot of the dialogue around, are the like AI as sort of a being or like its own sentient being kind of take hold among a lot of people. It's because it's just a more accessible metaphor. I think though, for my purposes, that's something we write a lot about. We write a lot about how these aren't, as we try to explain how these systems work, we try to use metaphors and color and things that people really understand. I will say, though, that when it comes to the copyright issue in particular, the AI systems, the AI companies have their own metaphors. I think it's really striking how there isn't much dispute within Silicon Valley and among the executives that yes, they did ingest copyrighted material. Like you can find this when, anyone will admit it. They're like, we just trained on the whole internet. I'm sure we sucked up some copyrighted material. But you shouldn't charge us for that anyway. And the metaphor that I'll hear a lot here is it's like somebody visiting a library and reading every book, except this is a system that can remember every book and remember all the pieces of every book. And so why are you harming this system why are you harming us for developing something that's so capable? The other more technical explanation you'll hear a lot is, just because it's trained on it doesn't mean that it's stealing it, it's learning from it, it's creating statistical patterns. And that speaks to the technical underbelly of it. And then, finally, the other sort of argument you hear from the tech companies is, okay, sure, yeah, there are lots of copyrighted material. There's a lot of this stuff in our training data, but no one piece of data is actually all that valuable, which I'm just laying these arguments out. Whether or not you believe them is subject to its own robust debate that I'm sure could fill 1,000 of these sessions. But in that argument, they're saying we need so much data that we are actually running out of data that you can find on the internet. Like we went through the whole internet. So like one book here and there, it doesn't really move the needle. So, how can you say that we are stealing when you know, each of these items that are publicly available online. I mean, none of it is. It's not like we need everything. That's where the value comes from. The value comes from the sort of sum total of the internet, and nobody copyrighted the internet. I think that there is a lot of power to the library metaphor. I think I've actually seen and talked to people who sort of struggle to combat that, and I'd actually love the opinion of all the different panelists on that. Like, is this not the same as going to a library? But the rest just, it sort of sounds like, listen, like it, I, it's harder to buy some of the other arguments that they make, especially when they say, don't charge us, which is something that Andreessen Horowitz's lawyers have said both in the UK and in the US. If you were to actually charge us for all the copyrighted material we sucked up, it would be it wouldn't be feasible and it would damage us. And therefore, the AI boom would halt and America would be behind. And, China certainly doesn't do this sort of stuff. So, and that isn't a legal argument, that's a political one. That's saying, we sucked up copyrighted data, but we needed to. And you need us to continue to go forth because otherwise China will win the AI war. And that's also a very powerful argument, or at least an argument that you hear a lot and that seems to have had some traction in DC. I guess I actually, if you don't mind, Anna, I'm not trying to steal your job, but I actually would really love to hear the opinions of any of the panelists just on that library metaphor and why it may or may not be the right one, because it's an argument I hear a lot here.
Sure, let's go to that, and then I'll go to attendees' questions.
Okay.
May I jump in?
I was going to say, it looks like Justin's anxious. Yes, please.
So Deepa, I thought you did a fantastic job, but wonderful job. No but there. But if you went into the library and you had a miniature photocopy machine with a automatic feeder, and you fed every single book in the library into it, no, that's not going to a library, right? And humans don't memorize like these machines do. And you said quite rightly that the AI people will say, "Oh, well, it's statistical patterns inside," and Wayne said a very abstract predictive model, and that's the whole point. And I welcome anyone here to email me or anyone you can find online. Take a look at the Disney and Universal complaint against Midjourney. And Midjourney is just churning out Disney and Universal characters, just 100% faithful, valid characters. And whether you call it statistical patterns or you call it very abstract predictive models, it doesn't matter. And this is what the court in Munich recently said is, in the European Union, it's not a question of fair use, it's a question of do you fall under the text and data mining exception. And the Munich court said, look, the fact that your AI system is churning out the entire song, the exact lyrics, means this was not training, this was not research, this was not experimenting, this was copying. And what's in the machine is a copy. So, so that's my reaction to the library idea. And the other part about the library idea is at the bottom of it, Deepa, isn't it really, you should treat my machine the equivalent of a human? And every journalist should push back and say, why do we treat your machine as the equivalent of a human? Might we live in a world where we privilege humans over computers? So at bottom, the library metaphor depends on the idea that the computer has essentially human rights.
Interesting.
Yeah, I'm happy to jump in too, if I can, on that.
Sure.
So I mean, I agree with everything Justin just said. I just wanted to add maybe also another way of looking at it. In terms of the library metaphor, in my view, I think it's just a little reductive. And what I mean by that is the metaphor starts to break down if you really dig into it. Like if training AI models on the collected works that are available on the internet or on notorious pirate sites, if that's just like a library, well, then why do we need it? We already have libraries, right? And so the response would be, well, because this technology can use these works in ways at a speed and a scale that are just far beyond the capabilities of humans. And so at that point, I think, well, now the metaphor's gone because it's not like a library. You've got a technological process or device that is doing something just completely different than what humans do. And I think that distinction is at the core
Terry froze for me. I'm going to keep going.
of the Copyright Act. It with a view, sorry, they were doing it with the view that technology changes things. Sorry if my connection is a little unstable.
You said something Comcast doesn't like, Terry.
Yeah, maybe that's it. So hopefully I didn't get lost too much, but I'll just maybe to state it another way. The Copyright Act is concerned with copying. And so, when someone goes to the library and reads books, there's no copying involved. But when you start taking textual works and translating them into tokens and creating word embeddings and word vectors out of them, and then using that to train a large language model or some other device, there's a lot of copying that goes into that. And it's not trivial. I mean, you're ending up with a commercial product that uses the expressive value that authors created, that publishers invested in, for the same purpose, to generate synthetic expression that sounds coherent and that sounds like what the stuff it was trained on. And so that's at the core of copyright. And all that means is that if AI developers want to be able to use this work, then they go to the copyright owners and they get permission or not. And I think the other piece of that is that just means there's a marketplace. And a lot of the issues related to efficiencies and scale that's needed for AI training, these are things that the market is very good at handling, right, over time. And what we've seen, unfortunately, instead, is a lot of AI developers rushing out the gate and not even giving the market that chance, going right to fair use, saying we need this stuff. We need to build the biggest models we can. We need to beat China. Take our word for it. This is going to be great. And we're just going to cut out a complete sector of the economy that's critical to the success of our models. And I think that's just in the long run, that's not good for innovation. It's not good for the creative sectors, and it's not good for the AI sector.
So sticking with you, Terry, and with the library metaphor, I'm going to go to a question from a copyright librarian at Bucknell University. Rachel Sweeney asks whether or not this use is truly transformative, whether you consider it that, understanding that there's a layperson use of the term, but the legal term involve something much more specific?
Yes, and I think that really gets at the core issue. When we think of transformative in the general sense, it's easy to look at what something like ChatGPT is doing and saying, "Wow, this is phenomenal. This is transformative." But that's not what it means in the legal sense, in the fair use sense. It has a more specific meaning, certainly complex, one shaped by case law and precedent. The Supreme Court just a couple of years ago in a case involving Andy Warhol and a photographer expounded on what transformativeness means. And so if we look at that, in my view, what training large language model and generative AI models is doing with the works that are being inputted into it is not transformative in that legal sense. Because what transformativeness is really asking a court to look at is, are you using a copyrighted work in a way that relates back to the original work, either by adding more context, more information, more knowledge about that work, right? So if you look at classic examples of transformative use, like a scholar quoting from a copyrighted work as part of a historical article or a biography, these are not just, things that enhance the work they're writing, but they increase our knowledge and understanding of the source works. And even with technological uses that have been found to be fair use, like the Google Book search, there's still that connection to the original work, right? In Google Books, Google was scanning works to build a search engine that allowed you to search for terms and then point you to where those terms appear in the books. So it's providing a more efficient way to get information about those works. But with generative AI, I think it's different because you're breaking that connection with the original works, right? You're essentially aggregating all these original works. You're building a statistical model that is sort of the average in some of the original works. And when you deploy that tool, when you use that tool, you're generating expression that doesn't shed light on the original works. It's just using them as like raw materials, the expression. And you may not even know what works the model was trained on. So it doesn't increase our understanding or provide new information or insights in the way that transformativeness in the legal sense has been fleshed out by courts to mean. So in short, yeah, I think in the life sense, it's easy to call this transformative, but when we're talking about fair use in the legal sense, I think it's much more difficult to say that this is transformative.
Terry, I will push back on that, I'm afraid, a little bit. I think you, for reasons of where you sit, you have a little tighter vision of transformativeness. So for journalists who don't follow this all the time or don't live and breathe this, transformativeness as set up by the Supreme Court has really kind of two branches. And Terry described them, but I want to clarify it for the journalists. And one is transforming the work with new expression, creating a parody version, creating a satire version, creating a criticism, new expression. And then a different version, which is a new use or a new utility. You should think as journalists of those as two distinct lines of transformativeness. And Google Books is really paradigmatic of the second type. And that is what we have now is we have a search function to find every occurrence of sumac in books published after 1952. And if you are a historian of the spice trade, finding every appearance of the word sumac after in books might be quite useful. And so Judge Laval in the Google Books case said the transformativeness here is creating a new functionality available to everyone. So on the ChatGPT side, just on a large language model, generative AI, some of what it's doing does appear to me transformative, right? In that when you're high school, when your child who's in high school no longer has to write her essays and ChatGPT does it for her, that is a functionality, a utility we never had before. I'm not saying it's a good one for society to have, but it's new. On the other hand, when ChatGPT or when a large language model just generates out Bob Dylan's song lyrics because you asked it to, or Midjourney just generates out Shrek because you asked for Shrek, I'd say that's not transformative. But Terry and I spend a lot of time doing things together, but I think that the transformativeness is a little broader than that. And I want to add, transformativeness just is part of one factor of four factors in fair use. So you don't win in fair use by simply saying it's transformative. And all courts say it's not just on-off transformative, it's how transformative it is. So there's a lot of courts who say, well, what's happening here is modestly transformative or transformative a little bit. Sorry, Anne.
No,
And I'd just like to add,
Sure.
I agree with the notion that it is transformative, and some of the judges in these cases that are going through right now agree that it is transformative. But when you have quite, and I think it gets back to the importance again of inputs versus outputs. If in fact you have Mid-Journey recreating Shrek or recreating Disney characters, those are, I think, something that current copyright law is more than amply, suited to settle those kinds of questions. So the training is a different question. If we are seeing outputs that are in fact direct copies of expressive works, clearly we've got copyright problems, and I think, like I said, I think the courts can handle that under existing copyright law.
Hmm. I do want to get back to some questions from attendees. Catherine Goldman, editor of Creative Law Center, asks, one part of the holding in the Anthropic case that resulted in the settlement was essentially that training the LLM on copyrighted materials was fair use. Fair use is a defense to copyright infringement, which means that copying must have taken place during the training. Is this correct? Does AI training involve copying, or is the use of the underlying copyrighted material transitory? Justin, would you like to take that one?
The answer is that early on, some AI companies claimed it was transitory, but there's almost surely multiple steps of reproduction in the act of training or the process of training. More importantly, and this is something journalists should keep in mind, and this has come up in a number of cases, is that when you're a large language model company, you have an incentive to keep a copy of the training set, and you have an incentive to keep copies of the training set. Why? Because as you tweak the algorithms of the large language model, you need to retrain it. And in order to determine what's happening with the algorithm, in order to determine how you're changing the system, you need the same input in terms of training data to see what your outputs are. So, discovery in the different lawsuits is slowly revealing this, but what is clear is that these AI companies are keeping unauthorized copies of vast copyrighted data sets. And so, yes, training itself invariably involves multiple steps of reproduction. That doesn't mean it couldn't be fair use, because way before AI, we did have computer software cases that had multiple steps of reproduction of software that determined it was fair use, but there's definitely reproduction going on.
Great. And now we have from Robert Cheney, a journalist in Montana, what is the fair use rule for reproducing a deep fake image? For a story exploring fake images on social media, is there any obligation to get permission from a creator? And can a non-commercial fake image have copyright protection? Interesting. Is there anyone who would like to chime in on that one?
I didn't know I would be asked to give free legal advice, and I don't think Terry wants to talk on this. I probably work more on deep fakes than anybody else on this. Don't worry about it. Use the deep fake picture in your blog post or your article. It's certainly fair use. It's criticism or commentary on the image you're showing. As to whether or not the image you're showing has any copyright at all, if it is a 100% indistinguishable deep fake of Taylor Swift, there's a very good argument that it can't have any copyright at all because it has no originality, because it is just Taylor Swift's face. And an absolutely faithful, indistinguishable deepfake reproduction of Taylor Swift or Robert Redford or Elizabeth Taylor or Beyonce's face arguably doesn't have any originality, so it arguably doesn't have any copyright. But I think you're You as a journalist, if you are writing an article discussing the issue, you're completely safe under fair use. This will come as commentary or criticism and definitely of a matter of public interest.
Thank you. And Philip Hill of Pygmalion Publishing asks, what impact will the Matthew McConaughey suit have on the AI issue regarding use of likeness and voice? And also, if my novel is copyrighted and I produce a movie based on the novel using AI, is that movie also protected? Terry.
Yeah, I'll take the second question because I have to admit I'm not familiar with the Matthew McConaughey case, but this kind of ties into the previous question on deepfakes that Justin was answering. It, there's this general question of if you're using AI tools to create works that are otherwise, the type of subject matter that can be protected by copyright, do you actually have copyright protection over those works? The Copyright Office in the US issued a report on this, I think, a year ago, looking at this general issue, and lots of folks are interested in this because lots of folks are using AI tools to either support their creative endeavors or even create things from scratch where maybe they weren't maybe they're not a graphic designer and they want to create images or illustrations, and now they have tools that at least in theory let them do that. So it's not an easy question to answer because there's a lot of it depends in there. What the Copyright Office said was basically if all you're doing is putting a prompt into a tool and then getting something out of it, whether it's an image or text, that's probably not enough to give you copyright protection over what comes out. Where it gets murky is, what if you are doing more than that? And at what point have you done enough that you have the level of human involvement in the resulting work to get copyright protection? So, I think that's going to be highly fact dependent. There are some also interesting twists where what if instead of using like a general purpose model out there like ChatGPT, maybe you're training your own model and you're training it or fine tuning it on your own works. And so it's a little bit different because now not only do you have, your creativity in the prompt and whatever comes out, but the model itself is also kind of a reflection of your creativity.
Mm-hmm.
So, that may also be a situation we see. So it's not easy to answer. I would say just as a basic level, though, you need some level of human involvement in what comes out. And it may be the case that if you write a novel, and I'm prefacing this by saying this is not legal advice, but it may be the case that if you write a novel and then you use AI to create a film version of that, because it's based on something that you wrote with your own creativity, maybe that's sufficient to have copyright in the movie version of it. But it's all going to depend on exactly what level of involvement it is involved in creating that final work. But it's a big question. I think it's also one we'll see evolving over the next couple of years as courts look into all these different types of scenarios where it's going to come up.
I think Terry's right. And doctrinally, let me explain that what would happen is we don't live in a world right now where you can just put the novel in and the AI generates an audiovisual work, which is a dramatization of it. But should we live in that world, you just take your novel and you put it in, then the court would be confronted with this question: is that resulting audiovisual work a derivative work? And our current doctrine requires the derivative work to have had some human creativity. That's kind of something that might shift with AI. But if it isn't a derivative work, you might be doctrinally, a judge might be required to say, hey, that audiovisual AI generated audiovisual thing, That's just a copy. It's a strange form of copy, but it's a copy of your novel. And therefore, it has its own copyright protection, but it's the novel's copyright protection. On the first question, the Matthew McConaughey, as I understand it, is attempting to assert trademark rights over his likeness and his voice and his phrase, all right, all right, all right. And the problem we're facing right now when it comes to deep fakes, and everyone in tech, journalists and people who write policy journalists need to understand this, is we have plenty of laws on the books to stop people from or to make people liable for creating a deep fake of you or a deep fake of your voice. The problem is we don't have any laws on the books to get those off the internet quickly. And that's the reason why there is a group of 4 senators have repeatedly introduced a bill in Congress. I don't know where it is now in terms of traction, called the No Fakes Bill. But many of your tech journalists and policy journalists know about the Digital Millennium Copyright Act from 1998. And what it did is it created a takedown system for copyright infringement. There's no statutory equivalent for trademark infringements, although many internet providers essentially use the DMCA for trademark infringements, and there's nothing like it for deep fakes. And so plenty of laws at the state level and the federal level against deep fakes, but do you want to go out and have to sue everyone and the damage is done when the deep fake is out there and has ruined your reputation already? So what we're in need of in the US, in my opinion, is something that gets those off the internet quickly.
That's a whole other webinar that we could do for sure.
Happy to do that one.
One final question from attendees. We have someone who is in the music business, and kind of speaking of the various formats issue that we got into, would the same principles that apply to the written work or image cases also apply to music? And they're referring to music composition, not simply lyrics.
The answer is technically yes, but proving infringement of a musical composition requires proving, for all copyrighted works, proving if you don't have an exact identical copy, what you need to prove is a standard in the American law called substantial similarity. Proving substantial similarity with musical compositions is more complex, more daunting than proving substantial similarity with visual works or with text-based works. That's the best answer I can give, Anne, in that short amount of time. But technically, the same rules apply, but the application of those rules is considerably more complex.
Thank you. And I'd like to ask one final question for each of you, but I'm hoping we can start with Deepa. What is one issue around this, or it could be a specific case that you think deserves more attention from journalists?
I think in general, these lawsuits haven't been as well covered necessarily. I think like understanding the arguments of I think understanding the broader copyright in and of itself, copyright law is sort of esoteric for a lot of us in our worlds, and then you're adding generative AI on top of it. I think so. I don't think there's been some reporters doing really great, robust reporting on the cases, but not enough of it. And I'll take a little bit of responsibility for that as well. That's especially since there's been a lot of really interesting stuff that comes out of discovery that helps understand like how the tech companies in and of themselves are thinking about this material. I think that there should just be, and I'm mostly speaking to myself now, but more explanation of that, or like a clearer way of like telegraphing to the audience, this is how the companies view this content and this is why they think it's justified and these are the counter arguments. And just clarity in general, I think would be great.
I think that's super interesting, especially since some, have been so secretive. So for that kind of insight coming out in discovery, I think is a really good point. Wayne.
Well, I think it's important when we think about this. We're kind of living in a pretty exciting time where a whole new disruptive technology is coming into play, and it's easy to get stuck in the rabbit hole of thinking about copyright and you're really in the weeds on this topic. But I think it's important to step back and look at what this technological revolution is unfolding into. This affects every sector of our economy. It goes well beyond the creative content industries. And keeping in mind and following that, I think, is very important. Because, I mean, if you go back to the Constitution, the whole role of the copyright clause is to promote the progress of science and the useful arts. And this goes throughout knowledge, throughout the economy. So the whole idea is expanding knowledge, expanding the ability for innovators and producers to create new things. So don't get too caught up in the weeds and think about the overall impact of where we're heading, I think is important to keep in mind.
Thank you. Justin.
Well, first of all, I agree 100% with Deepa. It's really esoteric. I want to express my admiration to journalists who try to master it because I know they have to jump from subject to subject. So it's tough, and those of us, folks like us, need to do a good job when you call or ask, explaining it from the ground up if need be. I would just say to journalists, look, understand that the behavior here of AI companies and the assertion of fair use is completely understandable. In our market capitalist system, all players want something very simple. They want their inputs for little or nothing and their outputs to be very expensive. And the fair use argument is all about AI companies wanting their inputs to be free, just like ranchers want their grazing land from the federal government to be free or their mining rights to be free. No different. No different than when the audiovisual companies, the movie studios, don't want to pay actors and writers very much. They want their inputs cheap and their outputs expensive. I also would say to journalists, be careful and be willing to push people when they make arguments because, Wayne is completely right that we are at a disruptive technology moment with tremendous opportunities, but the AI system necessary for discovering new drugs does not need to copy Iron Man or Absalon of William Faulkner. The AI system necessary for managing energy infrastructure does not need to copy all the music on Spotify. These are different things. And when an AI person asserts that to, push them back, say, what's the connection? So push him into the weeds. Unlike Wayne, I'd say push him into the weeds on this. Make him responsible.
Great. And Terry, last word goes to you.
Great. Well, thank you, and really appreciate inviting me again and being able to talk about this. So, just to add on to what everyone has said, which have been excellent points. The other thing I would highlight is just what is happening in the marketplace regarding licensing of all types of copyrighted works with AI developers. There's been a lot of great reporting on it, and especially some of the high-profile licensing deals out there. I mean, we saw just before the holidays, Disney and OpenAI entering into a deal. Some record labels, arising out of litigation they brought against some AI companies have settled and entered into licensing deals. But there's a whole universe of all types of activity happening in the marketplace that I think is exciting, that I think is leading to innovation. There are new entrants coming onto the market who are in the business of helping to address some of the scale and efficiencies that will really make licensing training data work so much better for everybody, and giving authors and others, copyright owners, the option to be able to allow their work to be used in ways that they agree with and that make business and economic sense, and prevent their works from being used in ways that they may disagree with for whatever reason. I mean, at the end of the day, that's kind of what we view copyright as doing, all right? It's a property right. It reflects the value that you put into, creative works, and all it gives you is the right to be able to say how those works are used by others, especially others who are deriving commercial value out of it. And so I think there's a lot of great stories that are happening in the licensing space, in the marketplace space, a lot of cool things that AI companies are doing with creative works, and a lot of cool partnerships. So, I would just want to highlight that.
Well, speaking of licensing, and for any journalists tuned in who are interested, I'm pleased to share that we'll be holding another webinar specific to AI and licensing the third week of February. So details on that will be published soon. So please, subscribe to our newsletter for that announcement, and the link to that is in the chat. I would like to thank all of our panelists for sharing your time and expertise today so generously. I'd like to thank the Copyright Alliance and Next Solutions Group for their sponsorship, and thank you to everyone who tuned in to today's briefing for asking such wonderful questions. I hope to see you at the next one, and thank you all and take care.
Thank you.